Well, thank you very much, Madam Chairperson. Indeed, yesterday we did ask a lot of questions from representatives of the Department of Public Safety and also the Parole Board of Canada. Now, personally speaking, I would have gone further with this legislation. Victims should be entitled to get access to information not only at the point of sentencing but well before that. And I even referred back to the Canadian Victims' Bill of Rights, sections 7 and 8, which states that victims are fully entitled to have all that information. And all the debate that ensued was about this phrasing upon request. The House of Commons Justice Committee had recommended in its report that this no longer be a quote-unquote upon request, that it be automatic because it's a right. And I reminded the witnesses and viewers, having worked on this issue for quite some time, all the medical studies demonstrate that victims have suffered a post-traumatic shock that endures for years. And they can't make well-informed decisions necessarily. And you can't ask victims to have this burden put upon them to have to read through a 6-page form, understand their website, update their registration, and get lost in red tape and the administrative process. I'm a lawyer and I understand you, Ms. MacDonald. It is impenetrable, incomprehensible. Yesterday I asked the government's representative if they dealt with the community organisations and on the ground, and the witness said, well, they have trouble locating the victims, and we couldn't understand that. The victims are there at the hearing, they're there in court. We asked if it was possible to reach out to those victims and to work with them in a humane, compassionate way. It's all well and good to receive a letter, but some of these template letters are also incomprehensible, impenetrable, not compassionate. I don't understand the government's approach. You know, these victims are there in the hearing, in the court case, and even victims need to understand the process of being a witness. Sometimes when you're a victim of domestic violence and you're asked to testify, and this is well before sentencing, it's really tough for the victims. They need support. I know that I'm preaching to the converted, and I'm sorry I didn't thank you as a preamble to my question for the extraordinary work all four of you do. Thank you just so much from the bottom of my heart. But I'd like to hear more from you. This whole issue of upon request, that's what we see in the Canadian Victims' Bill of Rights. And that's what the government is saying to us. They're quoting that. They're saying it's upon request, so I'm doing my job. You know, if I'm not asked, well, and I referred them back to their targets and indicators, and the target that they set is 350 victims per year. That's it for those registrants with the Correctional Services Canada. And given the number of crimes that we see across Canada, that's not really ambitious, is it? So, as far as expecting that victims make the request for information, that's anathema to me. Or maybe you'll tell me that it should be upon request. And if that's the case, the government needs to do work upstream about how to approach victims, because currently they're not doing it the way they should be. And I'm sorry for how long my question was. Well, I can start. There are two issues, the whole issue of upon request and then the Canadian Victims' Bill of Rights. It's a terrific principle, but it's not binding statutorily, and that's our hobby horse at our association. We're trying to make the Bill of Rights binding, and you say upon request, yes, and I'm not going to repeat what I said previously. For some victims, it's just one step too many to have to take. This is their right. Why aren't they just given the right proactively, and then they can opt out, perhaps? Sorry, but in 2022, the Standing Committee of Justice on the House of Commons side recommended that it should no longer be upon request. It should be automatic and proactive. Did you submit a brief at that time? No, I wasn't around back then. I'm sorry. Inaudible for the interpreter. I'd just like to call on senators to look at Bill S. 265 that was introduced by Senator Boisvenu before he left the Senate. It was at second reading in the Senate, and it covers basically everything you said that is missing and that you're saying would be good to see. And it, in fact, amends the Canadian Victims' Bill of Rights at Section 6, saying that it would not be upon request. So here we have a bill that the Senate has before it that it's one step in the right direction, as you say, but we could have taken many steps, but we need to, thank you very much for that comment, Senator, but I do need to hear from the community organisations themselves. I want to know whether they agree with this upon request requirement or not. I'm really interested to hear your input, ladies.
Can we just have a very brief response from a couple of you, just because we're quite a bit into this round?
I think the Victims' Bill of Rights is a theory. In principle, it sounds great. In actuality, it doesn't do anything. Unfortunately, it basically says, here are your rights, and if they're not being respected or upheld, then you have the right to make a complaint. Well, we make a complaint and on behalf of our victims with their support, and they may never hear anything back, or it might be months, or they tell them, okay, because you've got this letter or request put in, now you can know that the trial's actually, the parole board hearing is actually going to be tomorrow. But you can't appear in person because of COVID or whatever the reason is. So it exists in theory, but again, the advocacy piece. So I think people should automatically have a right to know. It shouldn't be by request. The request should be to opt out, because the amount of advocacy that people need to do in order to be able to even understand what's happening in the criminal justice system it's a full-time job to advocate for themselves and figure out what they're supposed to do and where can they get help. Is there funding? There is no funding. Like, all of these pieces take so much time.
Yeah, very quickly, first to touch on your mention of the system reaching 350 victims. I will tell you that our small team of 8 frontline staff reached 35,000 victims in the last 5 years. Less than 30% of the work we do is sustainably funded. So that hopefully speaks to the issue of the 350. I do believe the upon request or as requested needs to be removed from Section 7 and 8, because, again, if we don't do that, we're sending a message to victims again that they need to request the information. We want to change the Act so that accountability shifts, but I also think there needs to be a removal of the final statement in the Victims' Bill of Rights, which I referenced in my speech, where I quote, "No cause of action from an infringement or denial of a right under this Act." So we have an act that's telling victims of their rights, and then at the very end of it saying, but if your rights are violated, you have no cause for action. That also needs to be removed.
Thank you very much.